This is America at 250. Due Diligence.
The Free Press on Trial.
Here's Steve Herman and Bill Bernardoni.
Welcome to America at 250 Due Diligence. I'm Bill Bernardoni.
And I'm Steve Herman. This week's a little different. We're taking you inside a live event.
On July 21st, we brought the show to the National Press Club in Washington, D.C. for a special conversation on the First Amendment, hosted in their First Amendment room, the Free Press on Trial.
We heard first from Catherine Herridge, the investigative journalist currently facing an $800 a day contempt fine for refusing to name a confidential source. Then a panel of veteran reporters and First Amendment lawyers dug into her fight, a pre-dawn FBI search of a Washington Post reporter's home, and subpoenas served on New York Times reporters and subsequently retracted, and what it all means for the future of a free press.
We'll stay out of the way and let them make the case. Here's that conversation edited for time, recorded live at the National Press Club.
Welcome to the National Press Club, the place where news happens. I am Mark Schoeff Jr., the 119th club president and the financial services reporter at CQ Roll Call. It is a pleasure this afternoon to host this conversation on the First Amendment. As our country celebrates its 250th birthday, this is a critical moment to assess where we are on freedom of the press and the public's right to know. The club is pleased to welcome today America at 250 Due Diligence and its hosts, former Voice of America White House Bureau Chief Steve Herman and nationally syndicated radio host Bill Bernardoni. Steve and Bill created the radio program as a nonprofit, nonpartisan, independent, weekly, limited-run show to reach across the political divide and put into context key contemporary constitutional issues through discussion with only two restrictions: no hot takes and no name-calling. The program relies on grassroots donations and the institutional backing of the Jordan Center for Journalism Advocacy and Innovation at the University of Mississippi, where Steve is the executive director. The center is at the university's School of Journalism and New Media. Steve and Bill will explore current First Amendment challenges with journalism and legal experts Tony Losey, Laura Handman, and Eric Hageman, whom they will introduce more fully in a moment. And I'd be remiss if I didn't mention why it's so important to me personally that we host this conversation here at the National Press Club. The club is a vocal and consistent advocate for press freedom, one of the 5 freedoms protected by the First Amendment. We do this not because journalists are more special than others, but because press freedom ensures that each American has the free and unfettered flow of information that helps to inform, educate, and empower them to participate in the world around them. We do this work primarily through our nonprofit affiliate, the National Press Club Journalism Institute. If you are interested in getting involved or even donating, please look for the QR codes we have just outside this room. And now, here's Bill to introduce Catherine Herridge.
Catherine Herridge is an Emmy Award-winning veteran investigative correspondent who has covered national security and intelligence for ABC, Fox, and CBS. In February of 2024, Herridge was held in civil contempt by a U.S. federal court for refusing to disclose her confidential sources for a series of national security reports on Fox News in 2017. Later this summer, Herridge and her legal team will ask the Supreme Court to consider her First Amendment case, which has significant implications for journalists across the United States. On July 2nd, the court denied Herridge's application to halt the $800 a day in court fines. Today, Herridge works as an independent journalist on X, YouTube, and through her newsletter. She has reported from Afghanistan, Iraq, Qatar, Israel, Northern Ireland, Russia, and the former Yugoslavia. A graduate of Harvard and the Columbia School of Journalism, she founded a national security reporting scholarship at Columbia. Catherine Herridge.
The National Press Club, the Reporters Committee, the Society of Professional Journalists, the Freedom of the Press Foundation, the Coalition for Women in Journalism, the Knight First Amendment Institute, the Columbia Journalism School, and Fox News. Thank you for your support. This case is much bigger than a single reporter and a single story and a single news outlet. It's about safeguarding the fundamental principle of investigative journalism, the credible promise of confidentiality we make to our sources. My current situation stems from a Privacy Act lawsuit in which I am only a witness. In 2017, I did a series of reports for Fox News that presented information about an investigation into the plaintiff in the current case, Yanping Chen. She had founded and was running a university that catered to U.S. military personnel and received U.S. taxpayer funding through a tuition assistance program run by the Defense Department. In a separate 2018 decision, the Defense Department revoked her government funding and publicly announced it was doing so on national security grounds. Importantly, this is not a defamation case, claiming that my reporting was not accurate. Instead, the plaintiff is seeking my reporting sources as part of a Privacy Act lawsuit against 4 federal agencies. The plaintiff is trying to recover as Privacy Act damages the taxpayer funding that the Defense Department deliberately cut off on national security grounds. In 2024, when I was held in contempt, our teenage son asked me whether we would lose our house and savings and I would go to jail. I wanted to tell him that in the United States, where we claim to value a free press and the First Amendment, such an outcome was impossible, but I could not offer that assurance. At a time when many corporate media outlets choose to settle or pressure journalists to surrender their notes, I want to acknowledge that Fox News has continued to stand behind me and fully support the First Amendment and investigative journalism by paying my attorney's fees, even though I left the network 7 years ago. Our legal team looks forward to presenting our petition for cert to the Supreme Court. We believe the critical First Amendment issues in this case merit the court's review. It should concern every journalist and every American who values a free press that vital First Amendment rights are being decided in a case where the courts have kept important evidence secret from the public by keeping the documents under seal. I have never seen this evidence, but court records confirm it includes the Defense Department's decision to terminate the plaintiff's federal funding on national security grounds. The public deserves to know whether the damages the plaintiff seeks under the Privacy Act resulted from my reporting, as the plaintiff claims, or from that separate national security decision by the Defense Department. Serious journalists everywhere should demand the release of this sealed evidence so the public can fully understand what is truly at stake when courts impose fines and order reporters to reveal their sources. On Monday, I wrote my first check to the U.S. District Court for the $800 daily contempt fine. The plaintiff is now asking the court to increase the fines to $5,000 daily and bar third-party reimbursement for the fines. This is designed to break the journalist mentally, emotionally, and financially. While it's been a challenging time for me and my family who are here today, I remain committed to safeguarding the principles of investigative journalism and a free press. Thank you.
Thank you, Catherine, for agreeing to speak here today in the middle of a very important and sensitive case. Thank you, Mark, for inviting us to bring our radio show to the National Press Club. And most appropriately, in case those in the room didn't notice, we are in the club's First Amendment room. Our first panelist is Toni Losey. She spent 25 years as a reporter for some of the nation's biggest news organizations. She specialized in coverage of federal, state, and local law enforcement, the federal trial and appellate courts, and the U.S. Supreme Court. She began her career at the Pittsburgh Press, where she covered organized labor and federal courts. She also worked for the Philadelphia Daily News, Boston Globe, Washington Post, U.S. News and World Report, USA Today, and the Associated Press. She left daily journalism in 2006 to pursue a master's degree in the studies of law at the University of Pittsburgh School of Law. In 2008, she joined the faculty of Washington and Lee's University Department of Journalism, and she's teaching journalism skills courses. She also offers courses on covering the courts. In 2008, a federal judge in Washington held her in contempt of court for refusing to reveal the identities of confidential sources who provided information for stories she wrote for USA Today about the FBI's flawed investigation into the deadly 2001 anthrax attack. Tony, welcome. And I imagine that you listening to Catherine was either deja vu or PTSD.
No, it was deja vu. I mean, it's the same. It's the same playbook. It's the same misuse of the Federal Privacy Act. It's an end around defamation. It's a way to cash in and shake down news organizations. That's what it is, plain and simple. And Catherine is not being sued. I was not being sued. They were suing the federal government, and they wanted money. And they go after the reporters who work for the news organizations that they think have the deepest pockets. And back then, when mine happened, USA Today was the largest circulation newspaper in the country. And Gannett owned a whole bunch of newspapers and TV stations around the country. And so that's why there was a target on my back. And Catherine was working for Fox, and that's why she has a target on her back, because they're seeing money. And civil lawsuits are about money, nothing else, money.
Let's bring Laura into the conversation. Laura Hanman, representing content publishers, U.S. and foreign, digital, print, and broadcast, in for-profit and nonprofit. Laura Hanman's a partner at Davis Wright Tremaine, draws upon her 4 decades of experience helping her clients bring to light newsworthy information and then defending them from complaint through appeal. Along the way, Laura has established many of the key precedents that have strengthened the protection for content, winning the first U.S. decisions to refuse to enforce foreign libel judgments, leading to the passage of the Speech Act, establishing the standard in New York for libel by implication, establishing a heightened standard before the government can access records of a customer's expressive content purchases, establishing that internet rankings are opinion, defeating use of RICO in libel suits against advocacy groups, and securing for satire protection from libel and right of publicity claims. Laura's on the executive committee of the Reporters Committee for Freedom of the Press. Laura, welcome.
Thank you very much.
Laura, there's a lot going on right now, and I'm sure you're very busy. We have the DOJ case, Department of Justice case against the New York Times. There is a Washington Post reporter who has had her devices seized. And of course, Catherine's case, and there are a few others. Which of these, or maybe another one, that worries you the most right now?
Well, I mean, the one that is the most extreme was when the government knocked on Hannah Nathanson's door at 6:05 a.m. with a search warrant, and she was a Washington Post reporter, and seized all her devices, everything, including her watch. And even though it was an investigation into a leak of allegedly classified information, but they knew already, the government already knew who the leaker was. So they had no reason to do a search warrant and seize everything. At worst, they could have done a subpoena and asked for all the documents or information related to the person that they already had, arrested. So it was huge, and there even is a law, the Privacy Protection Act, that tells the government they can't do a search warrant on reporters unless they think the reporter is a suspect and has violated the law. And as the FBI came in and was searching her home, they kept saying, "You're not the target, you're not the target." So that wasn't the case. And what was unbelievable is that the government lawyers who sought the search warrant didn't tell the judge about the Privacy Protection Act. And when he found out about it after he had issued the search warrant, he was furious, as you can imagine, because honestly, the government usually enjoys a presumption of regularity, meaning they usually, judges defer to the government thinking they know what they're doing. I was an assistant U.S. attorney, and I very much benefited for that deference, but it's gone out the window, as many judges have said, and this one said it. And he is now going through, the judge is now going through all her devices to find the little shreds that relate to this one person. Now, she did unfortunately write a story about how she was the government employee whisperer and people had come to her. But that, doesn't mean that they should, do a search warrant and not tell the judge. And the judge said, if we let, the government wanted to be the one to go through all her devices. And the judge said that would be allowing the government fox to be in the Washington Post henhouse. And he rejected that. So he's been going through it. That one really scared me because it was so wrong. But there's so many others. As Catherine's case is another good example. I mean, there are, unfortunately, we did have almost a federal shield law that was called the Press Act, and it had been passed unanimously by the House. And then Trump was elected in 2024, and they shoved it and said no. The Senate did, and they never passed it. So while every state has a reporter's privilege protection, so if this were to be a state claim, a state civil lawsuit, you'd have to meet all the standards of the state shield law. Usually requires you to show this is the absolute essential critical evidence that it's not available in other places, that you've exhausted all the other possibilities. And that kind of showing is not made in the federal, when it's the feds who are doing it. And so hopefully, and of course, as you know, just in the last 2 weeks, the New York Times has had reporters have subpoenas come, the government sent people to their homes and served the subpoenas, and including a journalist who, interestingly, was the journalist who brought the challenge to the Pentagon press pass situation and said that that violated the First Amendment. And they've won so far on that, but they went after that reporter in specific with this search warrant related to the fact that Trump didn't take his plane from Qatar over from leaving Turkey because of concerns about security. And honestly, you don't need a leaker to tell you that the president would not have given up using that plane for any reason other than something really dramatically like security. And that's going on right now. And as you may have heard, the government also sought the records of, the phone and other suppliers like that, the phone companies, and even asked for one of the reporter's mother's phone information. Not clear if that was just a mistake or why they thought the mom would have anything.
We're going to be watching that very carefully, obviously. I also want to bring into our discussion Eric Hageman, who is a partner at Clare Locke, LLP, which represented a certain voting machine company in its suit against Fox News. Eric manages public-facing crises and represents individuals, corporations, nonprofit, and religious institutions in defamation litigation. He has litigated in state and federal trial and appellate courts across the country and has authored merits and amicus briefs in the U.S. Supreme Court and the Federal Court of Appeals. Before joining Clare Locke, Eric practiced appellate law here in Washington, D.C., in the offices of two multinational firms. Eric, the other night, we watched the president give a speech which touched on voting and elections. And it was observed by many in and out of the media that Fox News mostly ignored that afterwards. Does your firm get credit for that?
Well, I certainly don't get any credit for it because the settlement happened a few months before I joined the firm. It was the advertisement that drew me into the firm, so I'll take credit for that aspect of it. I think the Dominion case is a good example of why the current defamation doctrine is, I think, somewhat dated and is better adapted to a responsible legacy media than it is to people who are eager for clicks and who are out there to sort of spark outrage for its own sake. And I think the Dominion case is important because it has to be close to the absolute zenith of how much harm can be done when you have an irresponsible media actor or actors who are using the protections that they have doctrinally under defamation law to try to get away with something. And I'm glad that they didn't.
Anything you're looking out for right now that you see as a very significant developing case that we should know about?
I would hope that at some point, and I know this will be an unpopular thing to say in this room, I would hope that at some point soon the Supreme Court will reconsider Sullivan versus New York Times. I think it was clear, and it was sort of funny when I was thinking about what I would say tonight. It's an event on the First Amendment, and of course, on my view as a plaintiff side defamation lawyer, the First Amendment doesn't really have anything to say about defamation. There is only one thing doctrinally that I deal with on a day-to-day basis that has been constitutionalized by the Supreme Court, and that's the actual malice standard. But I don't think the actual malice standard has a basis in the Constitution. So in terms of what I'm looking for in doctrinal developments, it would be an opportunity cleanly to overrule Sullivan.
Can you explain a little bit in depth what that case is about for folks?
Yeah, so Sullivan is a 1976 case, and its practical import today is that there is under some circumstances there is a heightened standard that a plaintiff in a defamation case, it doesn't just apply to defamation cases, but it's mostly defamation cases. There is a heightened standard that a plaintiff must show in order to recover in a defamation action. And what that ordinarily entails is a showing that a reporter or an outlet, and by the way, it doesn't have to be a media figure. I mean, a lot of the people that we go up against are not involved in the media. But you essentially have to demonstrate in order to recover for defamation that the person you're suing knew or should reasonably have known that what they said or what they wrote was false. It's difficult for me to see certainly a textual hook for that requirement, which is treated as part of the First Amendment. I certainly don't see a historical one for it either. I think there would be some, and I'll say something just to suck up to Laura for a second. I think if embedded in state anti-SLAPP laws or in other state legislation, we saw something similar, and it was a product of democratic debate, I would have less of an aversion to it. The problem when you constitutionalize something, when the United States Supreme Court construes something in the Constitution to mean something that it doesn't, is that we, the people, do not have any recourse to that. We just have to keep filing lawsuits over and over again. And so I mean, another way of saying the same thing, if I would like to see Sullivan overturned, is I would like to see that issue returned to the democratic sphere.
Laura, I can see you trying to jump out of your seat here. What do you have a response, I'm sure?
Well, first of all, the good news from my point of view is that I don't think the Supreme Court's going to do that anytime soon. They just in 2023, more or less, embraced it in a different context and context of when threats are actionable. I'm proud to say that I did a case for Bloomberg News. They were reporting on a case that where someone had filed a petition for mandamus in the Supreme Court. And the guy who filed it is a guy whose father refused to pay taxes and was arrested and being picked up by the U.S. Marshals, and his son shot and killed 2 U.S. Marshals. And he was the one that was bringing defamation suit against Bloomberg for having reported inaccurately that the judge who gave the sentence is the one that said he justified the murders on political and ideological grounds, and in fact it was the U.S. attorney. And that survived all the way through motions, various motions. Anyway, it went up to the D.C. Circuit, and at the time, Justice Kavanaugh was a judge on the D.C. Circuit, and he reversed the lower courts that had denied dismissal and did a full-throated embrace of the actual malice standard and why it's so important to get rid of these cases early, because it can so chill speech on matters of public interest and debate. So I feel like the Supreme Court is in good hands on this issue, and they just recently, maybe a month ago, denied a petition for certiorari brought by Professor Alan Dershowitz in a case that he had brought against CNN, and raising the actual malice standard, and the Supreme Court denied certiorari, refused to review it. So I think, I feel that it's in good stead. I agree with Eric that, it most clearly and strongly applies when you're talking about government officials whose conduct is being debated. And that's where the need for public debate is so strong. But there's so many others who figure in our world and where the news reporting is important. So I feel very strongly that will remain.
Eric brought up anti-SLAPP laws, and for those who don't know, this has nothing to do with physical violence, SLAPP.
Not usually.
Okay. Who wants to explain briefly what are the SLAPP laws and why are they so controversial right now?
I took actual malice, so this is...
I'm happy to defend the SLAPP laws. And growing number of states, I think we might be up to 38 or so, have adopted. These are laws that when a plaintiff, someone who brings a defamation claim, trying about a matter of public interest and trying to get huge damages, they bring the lawsuit, and the court now will say, okay, you have to show you have a substantial basis for that lawsuit, or else we're going to dismiss it. And then they say, well, and you didn't show that, so now you need to pay the attorney's fees of the defendant, the person that you brought that against. And the person or party could be an advocacy group, it could be a news organization, it could be any number of folks who are raising issues of matters of public concern and interest. And the fees can be large, and in the U.S. courts, we don't get our fees unless we have this law. But this law is designed to discourage people from bringing frivolous lawsuits against news and matters of public concern.
Tony, let's bring you in here as someone who's practiced journalism for a long time, as someone who has been in a similar position to Catherine. What's your take on this conversation?
Well, I think that, the way I did it was very different. And I did survive without, ever giving up a source, without ever paying $1 in fines, and without ever spending a day in jail. And I took a different approach. I ran my mouth. I did not shut up. And I did not listen to my lawyers who told me to do the no comment thing, because I felt like I was being a hypocrite. I mean, I called people at home in the middle of the night and woke them up to get a comment out of them. I chased people on the street to get a comment out of them.
Take us back to this time when you found out that what was it, $5,000 a day?
It started out $1,000 a day. I'm sorry, $500 a day the first week, $1,000 a day the second week, and $5,000 a day the third week, I believe.
What was going through your mind as this was all happening?
Bring it on. Bring it on. I mean, I had to sit in a courtroom and listen to Judge Reggie Walton question my personal and professional integrity. And I walked out of there and I said, this is war. This is war. I am not going to stand, and I'm not going to cower in a corner. I'm not going to do it. And I fought back. I talked to anybody and everybody who wanted to ask me questions about the case. I talked to high school kids who were writing papers for English class. Mm-hmm. I talked to reporters all over the world. I went and I spoke to high schools. I spoke to community groups, journalism groups, and I kept the heat on. And so I felt that, that my strategy worked, and it worked very well.
I proudly did an amicus brief, a friend of the court brief, in support of Ms. Losey.
It was beautiful. I loved it. It was great.
I have to say, though, you were a teacher by the time you were under this. And,
yes. And
your students wanted to do a bake sale to
couldn't
pay your cookies, and they couldn't, right?
But because Judge Walton, I believe, is probably one of the first, if not the first judge who tried to do this. That he ordered me to pay these fines, and if I didn't, at the end of it, he was going to haul me back into court, and the threat was throw me in jail. But he added on to the fines, to that contempt order finding. He said that I could not take any money from anybody else, that it had to come out of my pocket, and I think he did say explicitly that he wanted to put pressure on me personally, which is what is happening with Catherine right now. And I do believe we appealed, and I got, Judge Walton refused to stay the fines, to pause the fines. And so we went to the DC Circuit and we got a 3-judge panel, and my 3-judge panel stayed the fines pending my appeal. And Justice Kavanaugh, who was then a judge on the DC Circuit, was a member of my panel. And I believe that just recently, when Catherine tried to get the Supreme Court to stay her fines, that Justice Kavanaugh went on the record and said that he would have granted her request to stay the fines. He has experience in that area.
Could you outline the story that's behind you getting fined for real quick for folks who might not be as aware?
Well, in 2001, within weeks of the 9/11 attacks, we started to hear about people dying of something called inhalation anthrax, which none of us had ever heard of. And it struck a chord with people throughout the United States because people get mail, and this came through the mail. And so it frightened people in a completely different way than the flying airplanes into buildings did. And so we were doing so much. I mean, we were working 6 days a week, 10, 12 hours a day. It was crazy. And I was assigned to keep tabs on the FBI's investigation of the anthrax attack. And the FBI was in over its head. The FBI back then was full of accountants, not scientists. And they had no idea what to do. And they were flailing around. And what happened is that the Attorney General of the United States at that time was John Ashcroft. And he went on all the morning shows, all the TV morning shows, and he came up with this newfangled term called person of interest. Now, every podunk sheriff in America uses it. And what it is a smear tactic. And it also was to try to calm the American people down and say, hey, we're on it. We've got our suspect. We're on it. And so John Ashcroft identified Dr. Stephen Hatfield as a person of interest in the anthrax attacks that killed 5 people. And I said, what's a person of interest? And I had sources of mine calling me, and they were losing their minds. These are the FBI agents were absolutely losing their minds and were so angry with Ashcroft for doing that. And I searched the U.S. Attorney's Manual, which is their Bible, and I could not find this term anywhere because it doesn't exist. And it was just a tactic, and it smeared him because you can be both a witness and a suspect and be a person of interest. And there's a big difference between being a witness and a suspect. But that's what this was about. It was about my following the stories that I wrote about the investigation. And there were 2 camps in that investigation. One thought Hatfield did it. The other one didn't. Thought that they'd gotten tunnel vision way too soon and that they needed to keep looking.
Little historical context. 1798, President John Adams, our second president. The newspapers are writing a lot of nasty things about him. He didn't like it. He had a thinner skin than George Washington did in the second term, that was for sure. So Adams sends the Supreme Court justices around as sort of traveling circuit judges to throw publishers and editors in jail on charges of sedition. We currently have a president who's been fairly litigious and probably, I think if you asked him, would say he'd like to throw some reporters in jail. Eric, if the president came to you and wanted to be a plaintiff, what advice would you give to him right now?
I would say it's a poor idea for the president of the United States to sue someone for defamation. I would also say that it's a poor idea for the president to throw reporters in jail.
Laura, how successful has the president been? You've been keeping track.
Well, since 2020, he's brought 16 lawsuits, or his company have sued the press for defamation primarily. And of that, I think he's gotten 2 settlements, as you know, ABC and CBS. He's dropped a couple suits, and some are ongoing, but I think 7 have been dismissed. And it caused me to think, well, have other presidents brought defamation suits against the press, either while they were president or after they left? And when I looked, I could find only one. And it was Teddy Roosevelt, and it was after he had left office, and he sued a local paper about allegations of drinking, and he got to a jury, and the jury awarded him 6 cents. And I don't know if...
Is that enough for a drink?
Back then, maybe.
We'll see. He did like to drink. He definitely did like to drink.
We'll see if Kash Patel has better luck against the Atlantic. We are taking questions from the audience in the room, so there should be a card on your seat, and we'll have someone pass those up to us, and in a couple of minutes take questions from the audience.
Tony, any thoughts on the FCC and what's going on with Brendan Carr?
Not really, no. I mean, I think that it's just another example of where the Trump administration is trying to intimidate the media. I think that is what's going on. But I think that all of these cases are disturbing. I mean, they're all disturbing. And I think that if you continue to undermine the news media like he's doing, it's trickling down. It is having a huge impact. The distrust that people have in this country for all institutions, but for the press, is concerning. It's very concerning. And he keeps beating that drum, that the press is the enemy of the people, the enemy of the people. And people are going to forget where they heard it, but they're going to think it. And they are thinking it. And that is a big problem for us.
We also have some interesting cases involving government-funded press. The Voice of America, where I used to work, is one example. And Stars and Stripes, where the Department of Defense or Department of War, wants to take direct control of it. These news organizations argue they, under the law and with the consent of Congress, had a certain level of autonomy. And those journalists are now using a First Amendment argument in their lawsuits. Laura, do they have a good case?
Well, Judge Lamberth, who is a federal district court judge in D.C., went totally with the Voice of America employees, said they should be reinstated. The appellate court, the D.C. Circuit, stopped that while it's going forward. But he's been holding strong, as have so many of the other judges in the federal court in D.C., and I'm just so impressed with them. And the rule of law, as far as judges go, has been very strong. And I think, that's a very good example of where, the Voice of America has been decimated. And
there's 6 out of the 48 language services on the air, very little programming, and much of it now sounding like administration press releases.
I think we're going to have some questions from the audience here.
Okay, I'll try to read people's handwriting. Question: who are the members of Congress most likely to press for some form of the SHIELD Act in the next Congress? Anybody want to take a crack at that?
That's easy. Congressman Raskin is extremely strong. He's also pressed, I should say, for a federal anti-SLAPP law. We were talking about the SLAPP law, and he pressed and introduced the federal law. Actually, a client of mine, a lawyer at Greenpeace, testified about lawsuits that have been brought against Greenpeace, and then the next day he introduced the bill, and it didn't get passed. He reintroduced it on a bipartisan basis. So I think between that and the federal SHIELD law, the Press Act, I think he would be the strongest. But, partly thanks to Dominion, there is support from conservatives as well, because, they see what can happen when you have to fight back against big lawsuits. And so the conservative press has been very supportive of anti-SLAPP laws, and of course also the federal SHIELD law to help reporters like Catherine and Tony if they get subpoenas from the government.
Here's another one. Every administration tries to stem the flow of leaks. How and has the Trump 2.0 administration been different? And do you think the changes, closing Pentagon, the press, and so on and so forth, will last beyond the president?
I think that they learned from their first term, and they're far more aggressive. They're far more organized in what they're doing. I think that the press has been weakened significantly. by a lot of changes in the business. Number one, social media. So it's wounded, and the fact that that the president can sue, CBS and ABC and walk away with settlements disturbs me. But these organizations are obviously making decisions that they don't want to fight him, and they're throwing money at him to make him go away. But he's not going away. He's not going away. It's only going to embolden him to continue to do this. And I think it's a dangerous time. I think it really is.
This is a good question. How can independent journalists who don't work for Bloomberg or the New York Times or other news organizations with lawyers and deep pockets stand up to the onslaught of lawfare from billionaires? Anybody looking for pro bono work?
Well, go ahead.
Yeah, I'll take that one. Tell the truth. And if you don't tell the truth, don't make it so obvious that you didn't know that it was the truth. I mean, this goes back to the anti-SLAPP issue. I think part of the reason that we're having issues with anti-SLAPP laws now is that the press is becoming so atomized. I think it's a good thing to have independent journalists, but the truth is you still have to be responsible. It's incredibly difficult to succeed in a defamation lawsuit. It's even difficult to threaten one. I mean, I have clients who are orders of magnitude wealthier than I will ever be, who still don't have the wherewithal to file or prosecute a defamation lawsuit.
Well, and in terms of defending journalists, which is what we do some pro bono, in other words, without charging. But there are also organizations like the Reporters Committee for Freedom of the Press, which I'm proud to be on the executive committee of, which provides services and guidance and can provide lawyers as well. And there are other organizations in that same frame.
Here's one. How do you think Americans' perceptions of the politicization, I can never say that word.
Politicization.
Speech impediment when I was little affects me with certain words, including that one. Of America's media affected their beliefs in the idea that journalists are deserving of these protections?
Well, I think that it's sort of become the wild, wild west out there. I mean, social media has put enormous pressure on journalists. It has. And unfortunately, I think there have been situations where, we have tried to, because these news organizations are trying to get eyeballs and people listening, and it is often difficult to do that with all the noise that's out there. So I think that like I said before, I think we're in a very precarious position right now. And we don't know how this is going to shake out. And there are some news organizations that are teetering, on the edge.
Quick follow-up to that. As someone who teaches the future journalists in this country, what are you seeing that what they want to do are doing? How are they handling this? And the want to be a journalist, but at the same time, understanding what you just described there? I
think they're as confused as the so-called adults are who are running these news organizations. Mm-hmm. The students that I have aren't sure, where is the business going? And what are the standards? Because sometimes they shift. And that is where, when that happens is that, that journalists, they incur the wrath of the public when they do that kind of thing. But I think that students, they're still trying to feel it out. And there's some that really, really want to do it, that have that desire, have that drive. And then there are other students who are just really unsure and wind up going to law school.
A lot of journalists go to law school. I hear the money's better. We have an audience member who says, I don't understand how a judge can violate the right of free association by prohibiting people financially contributing to Catherine's case, and also similar what happened to Tony, exactly what happened to Tony. And Any of the lawyers want to take a crack at that one?
Well, I mean, I think the judge is thinking, I've ruled that they have to testify, that they have to disclose their sources, but they're violating my ruling, and they're in contempt of court. And as you may remember, there are journalists who have actually gone to jail on occasion for that. And so what the judge is doing is trying every way to pressure the journalists to comply with his or her ruling. And you know, in a national security case, maybe that's, you know, justified. As you know, in Tony's case, she only didn't have to deal with it because the Hatfield settled with the government, and the government gave him a bunch of money. And
Yeah, but that was the thing with that case is that when Judge Walton imposed that restriction on me, you know, on our appeal, when we actually had argument before our 3-judge panel on you know, in the D.C. Circuit, and I really did believe that I was going to win on that one piece, and that would have helped Catherine if that had happened. And the Justice Department settled the case and threw a bunch of money at Hatfield because they had the wrong guy. They had the wrong guy. You know, and they screwed up, you know, not us. They screwed up. And Ashcroft is the one that released the hounds onto Hatfield by identifying him as a person of interest. But I did think that we were going to win on that one piece. And I refused to, because actually Judge Walton tried to get us to file a motion in the circuit to moot out my appeal. And I'm like, no. We want to wait. We want to wait and get a ruling from the court. Because we did well in that argument, I thought. And what wound up happening was Hatfield's lawyers filed the motion, and the circuit, my 3-judge panel with Justice Kavanaugh on it, wrote a fat paragraph that said that and they didn't just moot it out and say it doesn't matter anymore. They wrote a paragraph and they said that Losi did raise some interesting issues, you know, and I appreciated that. but the point is that, you know, those kinds of restrictions that Judge Walton tried to put on me and that the judge in Catherine's case is doing are, you know, they fly in the face of you know, your freedom of association, you know, and the way you spend your money. You should be allowed this. The Supreme Court has said in campaign finance cases that you're allowed that spending money is speech. So why not with helping a reporter pay a fine?
This is a perfect last question as we're getting ready to wrap up here. As we are increasingly witnessing, and this is a question from the audience, our democratic rights being undermined in this country, what is one key message that the public should be aware of from your perspective? Let's just start.
Well, you can't give up, number one, and you got to fight. You know, if they push you, you shove back, and you got to speak out. You have got to speak up. And keep the pressure on. If you sit there silently, you know, you're going to get run over.
I think in the age of the atomized media, the importance of independent thought and of verifying everything you read takes on a new meaning. It used to be that there were fewer media outlets. They were more aligned with each other and I think, frankly, with the truth. And now I think the truth is that the vast majority of media that people consume is kind of garbage. And it's not what's being pushed out by Laura's clients. It's what's out there on YouTube and on TikTok and all of these other places. And I think in Dominion and in other cases, we see every day how something that starts with a simple failure to verify a simple fact catches fire, and what's the saying? So a lie goes around the world 7 times before the truth gets its shoes on. I mean, this is happening every day. And so I guess my message would be independent, thorough thought, and not trusting other people to do your thinking for you.
And I guess I would say in the 250th anniversary that the Constitution stands strong. And in the Constitution is, Congress shall make no law against the press. And that is the watchword that we all should follow. And there's a reason, because the informed public needs to know what's going on in order to vote and elect and decide what should be their futures. So I say, look at the Constitution and follow it as best you can.
Thank you to all of our panelists. I'm going to leave it with an open question that came from the audience. The First Amendment was written when information was distributed by printing presses. Today, information is distributed by algorithms and influencers. How does this discussion apply to this media, and what constitutional questions should we be asking? That's for another panel and program. I want to thank our audience here in the First Amendment room of the National Press Club, as well as those watching on the video stream or listening on the radio or to the podcast. Thanks, everyone, for tuning in to America at 250 Due Diligence. On behalf of everyone here and my co-host, Bill Bernardoni, I'm Steve Herman. Thank you.
Send us your comments online at radiofreeamerica.media. That's radiofreeamerica.media. Executive producers of America at 250 Due Diligence are Steve Herman and Bill Bernardoni. Audio production by Bill Bernardoni of Bernardoni Media and Marketing. Support for the program comes from the Radio Free America Project and the Jordan Center for Journalism Advocacy and Innovation at the University of Mississippi School of Journalism and New Media. For more information, please visit newslab.org. Again, that's newslab.org.
Portions of this program are recorded at WUMS Radio in Oxford, Mississippi. For Steve Herman, I'm Bill Bernardoni. Thank you for listening, and we'll see you again next time as we continue discussing the ideas and principles that shape America at 250.